Good evening, viewers. So today we're going to discuss about various branches of government, that is legislature, executive, and judiciary. Okay. So first we will discuss about what is legislature and what is executive and what is judiciary. Okay. So legislature is a law-making body. Okay, and it constitute with three parts like Lok Sabha, Rajya Sabha, and President. Okay, and in executive part we'll discuss in executive part and what is the work of executive to execute law, okay, and judiciary to interpret the law. So which organ will call that executive? All the high rank ministers will call that they are the executive organs of government, okay. But in case of judicial, which organs we will call judicial body? Supreme Courts, High Court, they are the judicial organ. Okay, so today we are going to discuss about largely about legislature, executive, and judiciary. Okay, so legislature, the term legislature has been derived from the Latin word lex. Okay, which means a distinct kind of legal rule, mainly a general applications. Okay, that means it's a law making body. Okay, this rule is named legislation, and the institutions which enacts it on behalf of the people is known as legislature. Okay, essentially there are two models of legislative structures. Okay, the parliamentary and the presidential. Okay, in case of India it's parliamentary. Okay, the parliamentary model, the executive is selected by the legislature from among its own member. Okay, therefore the executive is responsible to the legislature. Okay, the presidential is based on the theory of separations of power and does not permit any person to serve simultaneously in both executive and legislature. Okay, in case of India, there is executives are always responsible to the parliament. Okay, and there is no provisions of any kind of separations of power. So in a in a broad way, that means India practices the rituals of the or the norms of parliamentary form of government. Okay, so now we'll discuss about our legislative organ. Okay, that about Lok Sabha, Rajya Sabha, and President. Okay, under the provisions of Article 75(9), the Parliament of India consists of presidents and two houses, that is Lok Sabha and Rajya Sabha. Okay, while the Lok Sabha is subject to dissolution, the Rajya Sabha is a permanent chamber, okay, which cannot be dissolved. The office of president is also remain vacant. Okay, so that means Lok Sabha is a lower house and Rajya Sabha is a upper house. Okay, Lok Sabha is a one kind of temporary house and Rajya Sabha is a permanent house because Rajya Sabha never dissolved. Okay, but in case of Lok Sabha, in every 5 years there is a conduct of general elections, and after the completions of 5 years, Lok Sabha dissolved and new election again conducted. Okay, so in brief way we will discuss about president. Okay, while the American president is not a part of the legislature, okay, the president of India is an integral part of the Indian parliament. Okay, in case of India. Okay, however he cannot sit and participate in the deliberations in any of two houses. Okay, the presidents of India perform certain important role like the parliament. Okay, the president summons and prorogues the house from one session to another and has the power to dissolve the Lok Sabha. Okay, a bill cannot be become law without the president's assent. Okay, even though the bill may be passed by both the houses. Okay, after consent or after signature of the president, then the bill become an act. Okay, the president also has the power to promulgate ordinance when both the houses not in sessions. Okay, these are the some basic power of presidents. Okay, so in a detailed way, when we discuss about executive, In that portion, we have detailed discussions about presidents. Okay, now we'll discuss about what Lok Sabha and what are the role of Lok Sabha in lawmaking process. Okay, the lower house of the lower house or the house of people is popularly known as Lok Sabha, or people of the country directly elect member of the lower house. Okay. Hmm. It includes not more than 530 members chosen by the direct elections from territorial constituencies in the states, and not more than 20 members to represent the union territories. Moreover, the president may nominate two members to Anglo-Indian community if, in his opinion, the community is not adequately represented in the Lok Sabha. Okay, so this is about compositions of Lok Sabha. Then the dissolutions of seats among the state is based on the principles of territorial representations, which means each state is allotted seat on the basis of its populations in proportion to the total populations of all the states. Okay, for the purposes of elections, each state is divided into territorial units called constituencies, which are more or less of the same size in terms of populations. Okay, that means Lok Sabha is a direct house. That means Lok Sabha elections held directly. Okay, in Lok Sabha elections, people are participate directly. Okay, so the members of Lok Sabha are elected on the basis of adult franchise. Okay, every adult who has completed the age of 18 years is eligible to vote. Okay, the candidates who receive the largest number of votes gets elected. The tenure of the lower house is, as I already discussed, 5 years. Okay, however, it can be dissolved earlier by the president. Okay. So to be a member of Lok Sabha, a person must be a citizen of India. These are the basic qualifications to be in case of a member of a parliament or Lok Sabha, and must have completed the age of 25 years. Okay, the person must also possess all the qualifications that are prescribed by the law. A candidate is free to contest from any parliamentary constituency of any states in India. The Constitution has laid down certain disqualifications for membership of Parliament. A person cannot be a member of both the houses of Parliament. Okay, a candidate may contest from several seats. Okay, however, he or she can have only one seat according to his or her choice. Okay, despite being elected from more than one seat. If a person is elected from both the state legislature and the parliament, and if he does not resign from the state legislature within the defined time period, he or she will fortify his seat in parliament. Okay, a member should not hold any office of profit under the central or state government except those that are exempted by a law of parliament, and should not have been declared as an insolvent or of unsound mind, okay, by a competent court. A member also gets disqualified on the following conditions, such as when he remains absent from the session of the House for a period of 6 days within prior permissions, or when he voluntarily acquires the citizenship of another country. Okay, in that cases, the member can be disqualified. Okay, or is under any acknowledgement or allegiance to a foreign state. Okay, so these are the some basic qualifications to be a member of Lok Sabha. Then now we discuss about compositions of Rajya Sabha. According to Indian constitutions, the Rajya Sabha or Council of State is the House of Representative of the state. Okay, the Rajya Sabha or the Council of State consists of not more than 250 members, out of which 12 members are nominated by the President from among persons having special knowledge or practical experience in literature, science, art, social services, etc. Okay, the remaining members are elected by the members of the state legislative assemblies on the basis of the populations of the state. Okay, unlike Lok Sabha, Rajya Sabha adopt the method of indirect elections. In case of Lok Sabha, there is a provisions of direct election, but in case of Rajya Sabha, there is a provisions of indirect elections. Okay, there is no uniformity in the members of representative of the Council of States. It largely depends on the population of the state. It means that the state which have larger population has more representative in the house compared to the states which have small populations. The member of representative of the states to Rajya Sabha varies from 1 to 34, okay, depending upon the populations of the state. The Council of States thus reflects the federal character by representing the states or the units of the federation. Okay, so Rajya Sabha is a continuing chamber, okay, or permanent chamber, as it is a permanent body not subjected to dissolutions. Okay, one third of its member retired in every 2 years, and elections are held for the vacant position. A member of Rajya Sabha has a 6 year term unless she or he resign or disqualified. Okay. Then now we discuss about what are the special provisions of Rajya Sabha. Okay. It has every right to seek information on all matters which are exclusively in the domain of Lok Sabha. It has no power to pass a vote of no confidence in the Council of Ministers. It also does not have much influence on the matter of money bill. Okay, in case of money bill, Rajya Sabha had no power, no such a strong power. Okay, however, the Constitution grants certain special powers to the Rajya Sabha. As the sole representative of the state, the Rajya Sabha enjoys two exclusively powers which are of considerable importance. First, under Article 249, the Rajya Sabha has power to pass a resolution by a majority of not less than two-thirds of members present and voting, declaring that it is necessary or expedient in the national interest. Okay, the matters in such a resolution should belongs to the state list. Okay, the law passed on the matter in the resolution shall be valid for 1 year. The second is Article 312 also provides special power to Rajya Sabha to pass resolutions or on another matter, that is to create or more all India services. That means Rajya Sabha special power covers two important articles, that is Article 249 and Article 312. Okay, like the resolution to be passed under Article 249, under Article 312 also the resolution should be passed by two-thirds of members present and voting in the House. Thus, these special provisions make the Rajya Sabha an important component of Indian legislature rather than just being a ornamental body. Its compact compositions and permanent character provide continuity and stability in the system. Okay, then who is the presiding officers, okay, of parliament. Okay, so each houses of parliament has a presiding officers. In case of Lok Sabha, presiding officers, a speaker. Okay, but in case of Rajya Sabha, presiding officer is chairman. Okay, so now we discuss about the presiding officers of Lok Sabha, that is about speaker. The position of the speaker of the Lok Sabha is more or less similar to the speaker of the English House of Commons. The office of the speaker is a symbol of high dignity and authority. Once elected to the office, the speaker does not have affiliation to any party but work in an impartial matter. Okay, he or she acts as the guardian of the rights and privileges of the members. Okay, the speaker has the power to ensure an ordinary and efficient conduct of the proceeding of the house. He or she conducts the proceeding of the house, maintain order and decorum in the house, and decides points of order, interpret and applied rules of the house. The speaker decisions is final in all such matters. The speaker clarify or certify whether a bill is moneyable or not. Okay, and she or he also authenticates that the house has passed the bill before it presented to the other house or the president of India for his assent. Okay, so this is all about our speaker. Okay, then now we discuss about chairpersons of Rajya Sabha. The vice presidents of India is the ex officio chairman of Rajya Sabha. But during the period when vice president acts as a president or discharges the functions of the president, he or she does not perform the duties as presiding functions of the or presiding officers of the Rajya Sabha. Okay, the vice president is elected by the members of both the houses of parliament assembled at a joint meeting in accordance with the system of proportional representations by means of single transferable vote system. Okay, so the vice president is not a member of either house of parliament or a house of legislature of any state. Okay, he holds office for a term of 5 years from the date on which he enters his office or until he resigns or is removed from his office by a resolution passed by a majority of members of the Rajya Sabha and agreed by the Lok Sabha. The function and duties of the chairperson of Rajya Sabha are same as those of the speaker of Lok Sabha. Okay, then now we discuss about our lawmaking procedures. Okay, so lawmaking is the primary functions of the legislature. As I already discussed that the main functions of Lok Sabha is to make law. Okay, the constitutions of India prescribe the different stages or some stages through which law can be formulated. Okay, the first stage of legislation is the introductions of a bill which embodies the proposed law and is accompanied by the statement of objectives and reasons. Okay, the introductions of the bill is also called the first reading of the bill. These there are two types of bills as like ordinary bill and money bill. Okay, a bill other than money bill or financial bill may be introduced in either house parliament, either houses of parliament. That means except money bills, other bills can be introduced, may be introduced in Lok Sabha, may be introduced in Rajya Sabha. Okay, so a bill may be introduced either by a minister or a private member. Okay, every bill that is introduced in the house has to be published in the Gazette. Okay, normally there is no debate at the time of introductions of a bill. The member who introduced the bill may take a brief statement, indicate broad the aims and objectives of the bill. Okay, if the bill is opposed at this stage, one of the member opposing the bill may be permitted to give his reason. Okay, after this, the question is put to the vote. Next process. If the House is in favor of the introductions of the bill, then it goes to the next stage. Okay. What happened in the next stage? In next stage, there are four alternative courses. First, after its introduction, a bill may be taken into consideration. Second, it may be referred to a selected committee of the House. Third, it may be referred to a joint committee of both the houses. And fourth, it may be circulated for the purposes of soliciting public opinion. Okay, While the first three options are generally adopted in case of routine legislation, the last option is resorted to only when the proposed legislation is likely to arouse public controversy and agitations. Okay, the day one of these motions is carried out, the principles of the bill and its general provisions may be discussed. Okay, if the bill is taken into considerations, amendment to the bill can clause by clause consideration to the provisions of the bill is undertaken. Okay, so this is this all the things are happen in second stage. Okay, then what happened in the third stage? In the third stage, the member is charged, moved, the bill is passed. Okay, at the third reading, the progress of the bill is quick, as normally only verbal or purely formal amendments are moved and discussion is very brief. Okay, once all the amendments are disposed, the bill is finally passed in the house where it was introduced. Thereafter, it is transmitted to the other house to its considerations. Okay, when the bill comes up for consideration of the other houses, it has to undergo all the stages which it has undergo in the house. Okay, where it was originally introduced. Okay, there are three options before this house. First, it may finally pass the bill as seen by the originating house. Okay. Second, it may reject the bill altogether or arm it and return to the originating house or original house. Okay. And third, it may not take any actions on the bill, and if more than 6 months passes after the date or receipt of the bill, it is considered as introduced. Okay. So the originating house now consider the please please mute your cell phone. So the originating house now consider the written bill in the light of the amendments. Okay, if it accept this amendment, it sends a message to the other houses of this effect. Okay, is if it does not accept this amendment, then the bill is written to the other house with a message to that effect. Okay, in case both the house do not come to an agreement, the president convenes a joint session of the two houses. The dispute provisions is finally adopted or rejected by a simple majority of vote of these two are present and voting. Okay. So this is all things are happening in third stage or final stage. Okay. Then a bill that is finally passed by both the houses is presented with the signature of the speaker to the president for his assent. That means after both the bills are passes in Lok Sabha and Rajya Sabha, then it's referred to the president. After president's signatures, the bill become an act. Okay. So this is the procedures of lawmaking. Okay. Then now we discuss about various parliamentary privileges. Okay. So parliamentary privileges are certain rights which ensure free and efficient functioning of the member of parliament. Okay. There are two types of privileges for the members of parliament, that is enumerated and unenumerated. Okay. The enumerated privileges are like freedom of speech in each houses of the parliament, immunity, okay, from proceeding in any court in respect of anything said or any vote cast. Next, immunity of liability in respect of publications by or under the authority of either houses of parliament or any report, paper, boards or proceedings. Next, freedom from arrest in civil cases for durations of the session for a period of 40 days. Okay. And next is exemption from attending a witness in a court. Okay. So these are the different parliamentary privileges. Okay. So this way the bill become an act. Then now we discuss in a brief way about state legislature. Okay. The state legislature consists of the governor, the state legislative assembly. Okay. In many aspects, the state legislature are similar to the Parliament of India. Okay. However, all state legislature do not have both houses, like legislative assembly, that is Vidhan Sabha, and legislative council, that is Vidhan Parishad. Okay. So the state legislature which have both houses are known as bicameral, or those which have only one house, that is Vidhan Sabha, are known as unicameral. Okay, the choices of having unicameral or bicameral legislature was left to the states, or it depends on the states. Okay, it depends on the assessment of a state where it wanted to have both houses or any one. Okay, the principal reason for not having both houses has generally been financial. Some states found it difficult to maintain cost of two houses. Okay, that is all depend on depend on states. Okay, whether they choose bicameral legislature or choose unicameral legislature. Okay, so this is then the legislative procedure in the state assembly is similar to that in the parliament with one significant exemptions. Okay, the governor can reserve any bill passed by the state legislature for the considerations of the president. This is the basic difference between our legislative procedures and state legislature, our parliamentary procedures and state legislature procedures, and other procedures are remain same. Okay, then this is all about our legislative organ of the state, how our legislative organ work, and how a bill become an act. Now we'll discuss about our executive branches of the government. As I already discussed that executive organs indicate that it's all about the high rank ministers, like prime ministers, presidents, council of ministers, chief ministers. Okay, so now we discuss about our presidents of India. What are the qualifications, what are the power, what are the positions, we discuss in a detailed way. Okay, so in article 52 to 79 in part 5 of the constitutions deals with the union executive. Okay, the union executive consists of the president, the vice president, the prime minister, the council of ministers, and the attorney general of India. Okay, the president is the head of the Indian state. He is the first citizen of India and acts as the symbol of unitary integrity and solidarity of the nation. Okay, so now we discuss the election procedure of president. Okay, the president is elected not directly by the people but by members of electoral college consisting of the elected members of both the houses of parliament, the elected members of the legislative assemblies of the states, and the elected members of the legislative assemblies of the union territories of Delhi and Puducherry. Okay, thus the nominated members of both the houses of parliament, the nominated member of the state legislative assemblies, the members of the state legislative councils, and the nominated member of the state legislative assemblies of Delhi and Puducherry do not participate in the elections of the president. Okay, this is most important. Okay, where an assembly is dissolved, the member cease to be qualified to vote on presidential election even if fresh elections to the dissolved assemblies, even dissolved assemblies are not held before the presidential elections. Okay, so the constitution provides that there shall be uniformity in the scale of representations of different state as well as parity between the states as a whole and the union of the elections of the president. Okay, to achieve this, the number of votes which each elected members of the legislative assembly of each states and the parliament is entitled to cast of such elections shall be determined uh, in in this way, like every elected member of the legislative assemblies of states shall have as many votes as there are multiples of 1000 in the quota obtained by dividing the population of the state by total number of elected members of assembly. Okay, the formula is value vote of a MLA is uh, total population of states divided by total number of elected members in the state legislative assemblies into 1 by 1000. This is the quota. Okay, then if every elected members of either houses of parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to member to the legislative assemblies of the states by the total number of elected members of both the houses of parliament. uh, this is the formula of MP. Okay, MP, that is the value vote is the value of a vote of all MLA of all state divided by total number of elected members of parliament. Okay, this is about MP. Okay, so electoral quota in which way electoral quota constitute? It constitute like in that manner, like total number of valid votes poll by 1 plus 1 equals to 2 and plus 1. Okay, this is the electoral quota. Okay, then what are the different qualifications to become a president? Okay, first is he should be a citizen of India. Second one, he should completed the age of 35 years. Okay, then he should be qualified for election as a member of Lok Sabha. Then he should not hold any office or profit under the union government or any state government or any local authority or any public of the union, the governor or any state, and a ministers of the union or any state, or is not determined to hold any office of profit and hence qualified as a presidential candidate. Okay, so this is about qualifications. Okay, then next is method of elections. The constitution prescribe an indirect elections through an electoral college. Okay, that is composed of elected members of the parliament and elected members of the state legislative assemblies. Okay, on the basis of proportional representations and by means of single transferable vote. Okay, based on the system of principle of uniformity among states and parity between the center and the state. The election procedures is designed to ensure the elections of a truly national candidate. Okay, so to ensure uniformity among states, the value of votes of elected members of the state assemblies is calculated on the basis of the total population, as I already discussed. Okay, then term of the office and removal of the president. The tenure of the office of the president is in India is 5 years. Okay, he or she comes from the date on which he or she assume office after taking an oath administered by the Chief Justice of India. Okay, then the president remains in office until his or her successor enters the office. However, if the president wishes to resign, he can send his resignation letter to the vice president. Okay, if the post of the president fall vacant, the vice president takes over the charge. Okay, but the elections for the post of president must be conducted within 6 months from the date of occurrence of the vacancy. Okay, so after in Article 56 and 61 deals with the procedures of impeachment, the impeachment procedures of the president. Okay, in this regard, the Constitution lays down that what is the main reason behind it? That is violations of the constitutions. If presidents of India violate the our constitution, then he can be impeached from his post. Okay, then, what are the powers of the president? Article 53 deals with the executive power of the presidents of India. The powers of the presidents are broadly divided into two types. namely ordinary and emergency power. Okay, the ordinary power of the president can be defined as executive, legislative, financial, and judicial power. Okay, so the executive powers of the power of the union and vested in the president under Article 53 confirm all executive powers in him and empowers him to exercise these powers directly by himself or through offices subordinate to him. Okay, Article 75 requires the Prime Minister to communicate to the President regarding all decisions of the Union Council of Ministers. Okay, so Article 77 holds that all executive powers of the Union government shall be exercised in the name of the President. Okay, so the president has both administrative and military powers. The supreme command of the armed forces is vested in him or her, and all appointment in the armed forces are made under the authority of the president as the supreme commander of the armed forces. Okay, so the president appoints the prime ministers and on the later advise the council of ministers. Okay, and the attorney general, the justice of Supreme Court and High Court, chief justice of Supreme Court and High Court, members of special commissions, okay, and the governor of the states are appointed by the president. So the choices of the prime minister is not discretionary prerogative of the president, but is usually detected by the party commanding a majority in the Lok Sabha. Okay, so in Article 254 empowers the president to remove inconsistencies between laws passed by the parliament and state legislature and the subject include in the concurrent list. Okay, there is another legislative functions of the president which has a bearing on states. The governor of a state can reserve certain bill passed by the state legislature for the constitutions of the presidents. Then its judicial power. The judicial power of the presidents of India includes the appointment of the justice of the chief justice of the Supreme Court and High Court, and the power to grant pardon, then deprive, suspensions, remissions, and commutations are of punishment of sentence of the court. Okay. These powers are granting pardon are given to the president for removing the extreme rigidity in the criminal laws and for protecting the past persons on humanitarian consideration. So these are all about the judicial power of the presidents. Okay, then what is the emergency power of the presidents? Emergency powers comes under like in that manner with the intentions of safeguarding the sovereignty, independence, and integrity of the Union of India. The Constitution bestows emergency powers on the presidents of India. Okay, so mainly the presidents of India enjoy three emergency power, that is our national emergency and state emergency or presidential rule and financial emergencies. Okay, so this is the emergency provisions, okay, which deal by the presidents. Okay, then our next we discuss about our prime ministers. Okay, so the real executive power under the constitution vested with the Union Council of Ministers with the prime ministers as its head. That means prime ministers enjoy a real power, whereas presidents enjoy nominal power. Okay, so the president is obliged to act according to the advice of the Council of Ministers, which is responsible in the real sense of the term. Okay, not to the president but the Lok Sabha. Okay, as in Britain, the prime ministers in India is usually a member of the lower houses of parliament. When Indira Gandhi was selected as a prime minister in 1990s in 1966, he was a member of the Rajya Sabha. Okay, that means Prime Minister may be selected from both the houses of Parliament. Okay, by getting elected to the Lok Sabha, she strengthened the conventions to the Prime Minister being a member of lower houses. Okay, So the prime minister is appointed by the president. However, the president has hardly any choice in selecting the prime minister. He can only invite the leader of the majority party in Lok Sabha, or a person who is in a position to own the candidate of the majority in the houses. Okay. So the prime minister holds office during the pleasure of the president. Okay. The pleasure of the president is related to the unwavering majority support which a prime minister received in the Lok Sabha. The president appoints the other members of the council of ministers on the advices of the prime ministers. A minister can be chosen from either houses and has the right to speak and take part in the proceedings of other houses through he can vote only in the house to which he belongs. Okay. Even a person who is not a member of either houses of parliament can be appointed as a minister, but he has a qualify for it by being elected or nominated to either houses within a period of 6 months. Okay, this is about prime minister. Then next we discuss about the council of ministers and the cabinet. Okay, the term cabinet is usually interchangeably with that of council of ministers. Okay, but they are different. Okay, in which way they are different? The council of ministers or the ministry consist of different categories of ministers. Okay, at the time of independence there was so much institutions as a cabinet in India. Okay, what existed then was the Executive Council. On 15th August 1947, the Executive Council was transformed into a Ministry of Council of Ministers that is responsible to the Parliament. Okay, so the term cabinet was used thereafter as an alternative to the Council of Ministers. At this stage, all the members of the ministry or cabinet except the prime minister had the same status. Okay, but the situations changed once junior ministers were appointed to the Council of Ministers. In 1950, based on the recommendations of the Gopal Swami Iyengar, a report, a three-tier system of the ministry was established with the cabinet minister at the top, ministry of state at the middle, and deputy minister in the lower rung. Okay, so in this way, the ministries can be categorized. Then the cabinet composed of the senior most ministers. Okay, whose responsibility transcend departmental boundaries into the entire field of administration. He is a similar body and the most powerful body in the government. Okay, the cabinet serves three major functions. That is, it is the body which determines government policy for presentations to the parliament. Then it is responsible for implementing government policy, and it carries out interdepartmental coordinations and cooperations. These are the main functions of cabinet. Okay, then we discuss about what is collective responsibility. Okay, the council of minister functions on the principles of collective responsibility. Okay, that means each member is responsible to another member for their acts of omissions and commissions. Okay, under these principles all ministers are equally responsible for each other and every act of government. Okay, that is under the collective leadership each members accept and agree to share responsibility for all decisions of the cabinet. Doubts and disagreements are confined to the privacy of the cabinet room. Once a decision has been taken, it has to be loyally supported and considered as the decisions of the whole government. Okay, if any member of the Council of Ministers is unable to support government policy in the parliament or the country at large, that member is morally bound to resign from the Council of Ministers. Okay, so this is the role of council of collective responsibility. Okay, this is the concept of collective responsibility. Then how we discuss about cabinet and the parliament. Okay, so the core of the parliament government is the accountability of the prime ministers and the cabinet to the parliament. Okay, the parliament does not govern, but critically examine the policies and acts of the government. Okay, and approves or disapproves of the theme as the representatives of the people. Okay, the very existence and survival of the prime minister and the council of minister depend upon the support they receive in the parliament. As we observe, the council of ministers is collectively responsible to the parliament. Okay, thus the general feeling is that the parliament controls the executive, but in reality, the prime minister, with his majority support, controls the very working of the parliament. Okay, so next we discuss about the sources of prime minister's power and influences. Okay, so though the constitution does not enumerate Though the Constitution does not enumerate the powers and functions of the Prime Ministers, in practice, he or she enjoys a wide range of powers as a leader of the Council of Ministers and the Lok Sabha. Okay, so the Prime Minister prerogative of constituting, reconstituting, and reshuffling the ministry, as well as charging the meeting vested the offices with considerable influence over the members of parliament. Okay, it must, however, be noted however noted that the prime minister has the freedom to select his colleagues, and it is subjected to his or her own position within the party. Okay, so for example, Indian prime minister Jawaharlal Nehru could not ignore Sardar Patel, who was very powerful in Congress party. These are the some examples. Okay, so next we discuss about the our judicial organ of the government. Okay, so this is all about from executive organ. Next we discuss about our judicial organ. As I already discussed that our judicial organ constitute Supreme Court, High Court. Okay, so next we discuss about Supreme Court or High Court. Okay, in a political system based on constitutional government, the functions of rule making or rule enforcement and rule interpretations are separated into three institutions, that is the legislature, the executive, and the judiciary. Okay, a judiciary that is independent of and acting as a check on the arbitrary exercise of legislative and executive power is an essential feature of a constitutional government. Okay, the judiciary is also the final arbiter of what the constitution itself means. Okay, in a federal system, the judiciary also serves as a tribunal for the final determinations of dispute between the union and its constituent units. Okay, given the tremendous importance of the role and functions of the Supreme Court and High Courts, various measures have been adopted to ensure the independent of the judiciary. Okay, so in which way? Next, we discuss the various compositions of Supreme Court of India. Okay, the entire jurisdiction has been divided into three tiers. Okay, all the top there is a, or in the apex level there is a Supreme Court. Okay, below it there is a high court. Okay, and lower rank is occupied by session court. Okay, so the Supreme Court is the highest court of law. The constitution says that the law declared by the Supreme Court shall be bind on all small courts within the territory of India. Below the Supreme Court, the High Court are located in the states. Under each house or under each court, there are district sessions court, subordinate court, and courts of minor jurisdictions, that is called small uh, cause court. Okay, then giving the importance of the judiciary in a federal system, resisting or limiting government, the Supreme Court was designed to make in the final authority in the interpretations of the constitutions. While framing the judicial provision, the Constituent Assembly gave a great deal of attention to such issue as the independence of the court, okay, the power of Supreme Court and issues of judicial review. Okay, so now we discuss about compositions and appointment. Okay, the Supreme Court consists of the Chief Justice of India and not more than 26 other judges. Okay, when the Supreme Court was inaugurated, it had only 8 judges. Okay, its strength has risen to 26 judges. Okay, the President of India, who is the appointing authority, makes these appointments on the advice of the Prime Minister and the Council of Ministers. The Constitution stipulates in Article 124, Clause 2 that the President shall appoint judges of the Supreme Court after consulting other persons beside taking the advice of his ministers. Okay, in the cases of the Chief Justice of India, the President shall consult such judges of the Supreme Court and the High Court, okay, as he may deem necessary. In spite of his clear constitutional provision, the appointment of Chief Justice of India has become a matter of political controversy. Here, it may be worth recalling the issue that were raised in 1973 when the government of India appointed Justice S.S. Roy as the Chief Justice of India, suppressing 4 other judges against the recommendations of the outgoing Chief Justice, okay, S.M. Satkari. Okay, avoiding political interference in the appointment of judges of the Supreme Court, some important qualifications have been set for the post, such as a person a person should be a citizen of India, a judge of High Court for at least 5 years, or should have been a advocate of High Court for at least 10 years, or a distinguished jurist in the opinion of the President of India. These are the some basic qualifications of judges. Okay, then tenure. Once appointment, a judge holds office until he attains 65 years of age. Okay, a judge of the Supreme Court may resign in his office or may be removed in his office in case of misbehavior or incapacity. This is the removal procedures of judges of Supreme Court. Okay, then next, we discuss about its various jurisdiction of the Supreme Court. First, we discuss about it. It have 4 type of jurisdictions. First is original jurisdictions. Second is appellate jurisdictions. Third is advisory jurisdictions, and fourth one is review jurisdictions. Then first we discuss about original jurisdictions. Okay, so the Supreme Court has original jurisdiction initially as a federal court. Okay, in a federal system like India, both the union and the state government derive their powers from and are limited by the same constitutions. Okay, differences of interpretations of the union states distributions of power or conflict between state governments, okay, require authoritative resolutions by a judicial organ, okay, independent of both levels of the government. Okay, under Article 131, the Supreme Court gives exclusive jurisdiction in a dispute between union and a state, or between one state and another, or between a group of states and other. Okay, in that cases jurisdiction, original jurisdictions arise. Okay, when we say that the Supreme Court has an exclusive jurisdictions, we mean that no other court in India has power to entertain such disputes. Okay, similarly, the original jurisdictions of the Supreme Court will remain that the parties to be dispute should be unit of the federation. So this is about original jurisdiction. Next is appellate jurisdictions. The Supreme Court is the highest court of appeal from all courts in the territory of India. Okay, it has comprehensive appellate jurisdiction in case of involving constitutional issues, civil and criminal cases involving specified thresholds, values of the property, or a death sentence, and a wide-ranging power of special appeals. Okay, and it constitutes Article 132. Okay, and next is advisory jurisdictions. The Supreme Court is vested with the power to render advisory opinion on any questions of fact or law that might be referred to it by the President. Okay, the advisory role of the Supreme Court is different from ordinary adjudications. Okay, in that session, first there is no litigations between two parties. Second, the advisory opinion of the court is not binding on the government. And finally, it is not existable as a judgment of the court. The practice of seeking an advisory opinion of the Supreme Court helps the executive to arrive at a sound decisions on important issues. At the same time, it gives a soft opinion or options to the Indian government on some political difficult issues. Okay, this is about our advisory jurisdictions. Then next is review jurisdictions. The Supreme Court has the power to review any judgment, pronounce, or order made by it. Okay, it means that the Supreme Court may review its judgment order. Okay, this is the review judgment or review jurisdictions. The Supreme Court in India is far more powerful than its counterpart in the United States of America. Okay, so this is about review jurisdictions. Okay, then next we discuss about High Court. The constitutions provide a high court at the apex of the state judiciary. Okay, chapter 5 of part 6 from article 214 to 231 of the constitutions of India contains provision regarding the organizations and functions of the high court. Okay, by the provisions of article 125, which says there shall be a high court for each state. Okay, this is article 125, and these courts have a constitutional status. The parliament has the power to establish a common high court for two or more states. Okay, for instance, Punjab and Haryana have a common high court. Similarly, there is one high court for Assam, Nagaland, Mizoram, and Arunachal Pradesh. Okay, then what is the compositions of high court? Unlike the Supreme Court, there is no minimum number of judges for the high court. Okay, the presidents from time to time will fix the number of judges in High Court. The Chief Justice of High Court is appointed by the Presidents of India in consulting with the Chief Justice of India and the Governor of the state, which in actual term means the real executive of the state. Okay, so it has also various types of jurisdictions. First jurisdictions is the original jurisdiction. The original jurisdictions of the High Court includes enforcement of fundamental rights, settlement of disputes relating to the elections of union and state legislature, and jurisdictions over revenue matters. Okay, it appellate jurisdiction extend to both civil and criminal matters. The civil matters, the High Court is either a first appeal or a second appeal court. Okay. In criminal matters, appeal from decisions of a session judge or an additional session judge where a sentence of imprisonment exceeds 7 years and other specified cases other than petty crimes constitute the appellate jurisdictions of a high court. In addition to the normal, original, and appellate jurisdiction, the Constitution vested High Court with 4 additional power. What are the 4 additional power? First one is the power to issue writs or orders for the enforcement of the fundamental rights. Then second one is the power of superintendence over all other courts and tribunal except those dealing with the armed forces. Okay. Next is the power to transfer cases to itself from subordinate courts concerning the interpretations of the constitutions. And fourth one is the power to appoint officers and servant of the High Court. Okay, so this is about our High Court. The next is subordinate court. Under the High Court, there are hierarchy of courts which are referred to it in the Indian constitutions and subordinate courts. Okay, since these courts have come into existence because of an enactment by the state government, their designation differ from state to state. Okay, however, there is uniformity regarding its original structures. Okay, so the state is divided into districts, and each district had a district court which has an appellant jurisdictions in the district. Under the district court, there are lower courts such as additional district court, sub court, munci magistrate court, court of special judicial magistrate of the class 2. Okay, court of special judicial magistrate for class 1, court of special munci magistrate for factories. Okay, and labor laws, etc. Okay, so at the bottom of the hierarchy of subordinate court are the panchayat courts. Okay, these are however not considered as court under the preview of the criminal courts jurisdictions. Okay, so this is all about our subordinate courts. Then next is judicial review. What is judicial review? Judicial review means any law which is created by the legislature or executive, and if that law is going against our constitutions, judiciary declare that law is unconstitutional or ultra bias. So this is the special power of judicial organ. Okay, so these pictures we borrowed from American constitutions. Okay, so this is all about from today's class. We will discuss about legislature, executive, and judiciary. So now, if you have any doubt, then you can ask me as soon as possible. Okay, so thank you. This is all about from today's class.